Good afternoon, everybody, and welcome. I'm Liz Reppy. I'm the Minnesota State Law Librarian. We have an excellent program planned for you today about early courts in Minnesota. Starting things off will be the Chief Justice of our current Supreme Court. Natalie Hudson was appointed Chief Justice of the Minnesota Supreme Court by Governor Walz just on October 2nd, 2023. Sorry.
Let's try 1800 something.
It's all these early dates that are in my mind. She was first appointed to the Supreme Court in 2015 by Governor Dayton, and also sat on the Court of Appeals prior to coming to the Supreme Court. She was appointed to that court in 2002 by Governor Jesse Ventura. Given her long service to the courts in Minnesota and to the legal community before her time coming to the courts, Chief Justice Hudson is a fitting person to start off our look at the courts in Territorial, Minnesota.
Thank you, Liz, and welcome to everyone. It's really good to see all of you here for this, what I think is just going to be a very exciting program. And to that end, today we are here to celebrate the 175th anniversary of the creation of the Territorial Government of Minnesota. The Organic Act of 1849 formed the Minnesota Territory, but it also formed the Territorial Supreme Court and the Territorial Library. Our two speakers today are amazing scholars of legal history, and we're so fortunate to have them with us. And they'll be speaking about the early history of the legal system here in Minnesota. Additionally, the staff of the State Law Library, which is a direct descendant of the Territorial Library, has created an amazing exhibit that highlights the early court. And we hope you'll stay with us to go view that exhibit, which is on display downstairs in the State Law Library. That exhibit highlights the early court, its justices, and the Territorial Library. Just some interesting tidbits and facts about the early Territorial Court. Approximately 20 attorneys were sworn in here in Minnesota in the first term of the court. And compare that now where we have almost 30,000 attorneys here in Minnesota. The Territorial Court consisted of 3 justices, many of whom also had duties as district court judges, which I can't even fathom at this point in time. 2 counties here in Minnesota were named for territorial justices, and so just a bit of trivia. Anybody have any idea what counties those might be? Oh, we need Justice Anderson. Where's Justice Anderson when you need him? He knows, I know, it's right. He knows this stuff. It was Meeker and Sherburne. So yeah, I didn't know that either. The Supreme Court, the Territorial Supreme Court from 1849 to 1858 considered 161 filed matters, resulting in 119 opinions, 58 of which were written. Compare that with the current situation. In 2022, we issued 127 opinions, but of course, back then, the Supreme Court handled all appeals, as opposed to now, when we have our Court of Appeals, obviously, that was created in 1983. Another interesting tidbit, all of the justices at that time on the Territorial Court were born on the East Coast. Of the 10 territorial justices, only 3, the last 3 that were appointed, were living in Minnesota before they were appointed to the court. So lots of other just fascinating facts and tidbits about the Territorial Court. But I'm going to leave the bulk of that to our experts here who have so much more to share with you. But again, just thank you all for joining us today. We hope you enjoy it. We hope you'll join us afterwards for the reception down in the Law Library and to take a look at the exhibits for yourselves. And so thank you, welcome, and with that, I'll turn it back over to Liz.
Thank you, Chief Justice Hudson. Next, I'd like to introduce our CLE presenters. Carol Chomsky is a professor at the University of Minnesota Law School, where she's been on the faculty since 1985. and served as Associate Dean for Academic Affairs from 2012 to 2015. She's taught courses and published books and articles on a variety of legal topics, including American legal history, history of women lawyers, and American Indian legal history. Also presenting today is Judge Tim Baland. Judge Baland served as the Minnesota 7th Judicial District Court Judge from 1984 until 2006. Judge Baland spent 2.5 years working as an international judge for the United Nations mission in Kosovo. He continues doing international rule of law consulting work, most recently in the countries of Georgia and Albania. And lastly, Judge Baland is the co-author of a fascinating law review, I highly recommend it, law review article that he authored with the former Chief Justice Robert Sharon, entitled "The Law, Courts, and Lawyers in the Frontier Days of Minnesota, an Informal Legal History of the Years 1835 to 1865. Lots of good stuff there. So please help me welcome our speakers.
On behalf of both of us, thank you, Chief. Thank you, Liz. Great to be here.
All right. So yes, on behalf of both of us, we are very pleased to be here to share with you a bit of the history of the Minnesota Territorial and Pre-Territorial Courts. As Justice Hudson has pointed out, it's going to look a little bit different than the current history and both informal and formal histories. Before we begin, we want to start by acknowledging the part of the history that we are not talking about today. It's become almost standard to start meetings with a land acknowledgement. And in keeping with that, we note that we gather today here on the ancestral lands of the Wapekute and of the larger Dakota Nation. But beyond that, we acknowledge that during the territorial and pre-territorial period we are talking about today, Minnesota was the then present home of the Dakota and Ojibwe people. In fact, by one estimate, in 1850, in Minnesota Territory, there were approximately 6,000 European American settlers, but 31,700 Native Americans. We were charged today with presenting about the territorial courts that were established 175 years ago with the establishment of Minnesota Territory. But it's important to frame that by acknowledging the part of the legal history of our state that we are not talking about today, the tribal government, the tribal laws, tribal decision-making. And so I want to acknowledge that at the outset, we're talking about one piece of our Minnesota history.
Thanks, Carol. And as you can see from the slide that's on the screen, the eastern portion of Minnesota actually came out of the old Northwest Territory. And because of that, Theodore Blegan remarked that Minnesota, and I'm quoting now, shares in the heritage of the Northwest Ordinance, the Magna Carta of the West. In the state's background is the pledge by the nation of states dedicated to the fundamental principles of civil and religious liberty. The state inherits guarantees of freedom of religious worship, jury trial, common law, habeas corpus, due process, the interdiction of slavery or involuntary servitude, save as punishment for a crime, and the pledge of encouragement of school and education through all time. As the states were carved from the Northwest Territory, and as you can see perhaps from the slide, Minnesota was variously part of the territories of Indiana, Illinois, Michigan, and Wisconsin. As you can see from the next slide, the western part of what became Minnesota was part of the Louisiana Purchase and later part of the Iowa Territory. As states were carved from this land, Minnesota was variously part of the territories of Louisiana, Missouri, and ultimately Iowa. While there were territorial courts within this jurisdiction over the area that became Minnesota, no territorial court sessions or hearings were convened within that geographic area until 1838. Let's spend a minute considering Minnesota became a territory. What was it like back then? Hiram Stevens, writing in the History of the Bench and Bar of Minnesota, says that, and I'm quoting, little or no control of law was exercised over the small and scattered frontier settlements and trading posts before the organization of Minnesota Territory in March 3 of 1849. But the law did come to Minnesota in those early years in the form of Joseph R. Brown and Henry Sibley. Each served as a justice of the peace, one Brown appointed by the governor of Wisconsin Territory, and the other Sibley appointed by the governor of Iowa Territory. And as you can perhaps tell from the map on the screen, the two of them wound up located quite close together. Brown was in Stillwater and Sibley was in Mendota. And that's because Stillwater was still part of the Wisconsin Territory and Mendota part of Iowa. So two justices of the peace side by side in an area with as yet a very small white population. Joseph Brown was born in 1805. He joined the Army as a drummer boy at age 14, and then came to Minnesota with the first detachment of troops under Colonel Leavenworth that built Fort Snelling. Discharged from the Army in 1828 at age 23, he worked for a number of years in the fur trade. In 1838, he was one of the first to stake a claim to land east of the Mississippi, ceded by the Dakota to the U.S., moving his family and business to Gray Cloud Island. Appointed Justice of the Peace by the governor of Wisconsin Territory, Brown held court at his trading posts in Stillwater and Gray Cloud Island. Brown simultaneously held elected positions as county clerk, county commissioner, and clerk of district court for St. Croix County. He was a member of the Stillwater Convention of 1848 and is credited with being the one who suggested Minnesota as the name of the new territory. He was a secretary for the first Minnesota Territorial Council, was elected to serve both on the council and in the legislature, and edited the influential local newspaper, the Minnesota Pioneer. Henry Sibley was born February 20, 1811. His father, who served as a time for the mayor of Detroit, later became the Chief Justice of the Michigan Territorial Supreme Court. Obtaining permission from his father to discontinue his legal studies, Sibley, like Brown, became involved in the fur trade, moving to Mendota in 1834. Like Brown, in 1838, Sibley was also named Justice of the Peace, but his commission came from the governor of the Iowa Territory. Sibley's jurisdiction extended over what is now northern Iowa, southern and southwestern Minnesota, and the eastern part of South Dakota. Historian Hiram Stevens called Sibley the first lawyer in Minnesota, even though he never really practiced law. Although justices of the peace technically had only limited powers, in effect their powers were much broader because the district courts were so far away. The first attempt to bring a district court judge from Madison was in 1842, but when he arrived, there was no business to be transacted. District court was not again convened in Minnesota's geographical area until 1847, 5 years later. Reflecting on the powers of his office, Sibley said, and I'm quoting, "I had matters pretty much under my own control, there being little chance of an appeal from my decisions. In fact, some of the simple-minded people around me firmly believed that I had the power of life and death."
So in the pre-territorial period, there isn't much by way of a written record, but there are some good stories. Here are two stories of cases in those early years, both illustrating something about the difficulties of operating in an area with complicated and crossing jurisdictional lines. The first case, and I'll explain why there's a map. I know it's a little blurry, but you can get a sort of sense. The first case in 1838 occurred when an Ojibwe named Chegahuascung, with apologies if I mispronounced that, was charged with killing Alfred Aitken, the son of an Ojibwe woman and the white agent for the American Fur Company. The killing took place in Wisconsin Territory up in the northern region. That's the point of the map, is to see sort of the spacing of the where, because as we talked about before, Iowa and Wisconsin Territory were close together. So the killing took place in Wisconsin Territory up in the northern region near Leech Lake. Because of the limited authority of the Justice of the Peace for that area, there was no power to hear this kind of case. He was taken to Prairie du Chien down the Mississippi River to the south for indictment and trial in Wisconsin Territory District Court. But the district court decided it didn't have jurisdiction over the crime for a different reason. It first determined that Aitken, with white and Ojibwe parents, was Ojibwe rather than white, an interesting and telling assumption about race in those early years. And because the alleged crime was then understood as occurring between two Ojibwe, the Territorial criminal court didn't reach the crime. It had to be tried under federal law. So Chegawasgung was released. It presages issues raised in subsequent years in cases crossing boundaries among tribal, state, and federal jurisdictional laws. There may well be another aspect to this case sounding in the broader history of Native white interactions. Dr. Carrie Miller, a descendant of the Leech Lake community and now on the faculty at the University of Manitoba, gave a talk in 2015 telling how 19th century Ojibways transformed the story of Chegawasgung into a tale that indicted white traders' greed and upheld their own national values. So there may have been much more to the story of the killing than is told in the versions in the published histories. The second case I want to talk about arose in 1839 when Edward Phelan, yes, that Phelan, a discharged soldier from Fort Snelling, allegedly brutally murdered John Hayes, another discharged soldier with whom he'd been living on a piece of land they claimed together. According to Hiram Stevens, in the history of the bench and bar of Minnesota, there was no doubt of Phelan's guilt, and Sibley, Justice of the Peace in Iowa Territory, issued an arrest warrant. As in the previous case, Phelan was taken to Prairie du Chien for trial. Prairie du Chien was the right place for trial because the murder was committed on the north side of the Mississippi River in Wisconsin Territory. Sibley was Justice of the Peace in Iowa Territory, not Wisconsin Territory, so he actually had no business either issuing the arrest warrant or ordering Phelan held for trial. The authorities at Prairie du Chien waived the point, and Phelan was held until the next grand jury convened. There is another version of the story. It's one of the things you find in researching this early time. Sometimes you get multiple versions of the same story. In that one, Phelan was turned over to Justice Brown, Justice of the Peace Brown, who held a hearing and remanded him to be taken to Prairie du Chien. He would have had jurisdiction, so a little hard to tell, but a number of the tellings does have Sibley taking the action. Either way, Phelan was held for the grand jury to consider the charge. But another aspect of early trials and law in Minnesota, the winter was long, the river was frozen, the distance between St. Paul and Prairie du Chien was long, so witnesses didn't show up to the grand jury and the prisoner was discharged. As I mentioned before, this is the Phelan after whom the lake and other landmarks in St. Paul are named, but perhaps not a man particularly worthy of the honor. Aside from this particular charge, he was later indicted for perjury by the first grand jury of Ramsey County after the territory was created and fled the area. He was also apparently murdered by fellow travelers while en route west because of some infraction he did. So perhaps we should consider renaming some of those landmarks. He owned a lot of land, and that's why there's so much named after him, because some of the land where Phelan Boulevard and Phelan Lake was from him, and that's where the name comes from, although spelled differently than he spelled his own name.
Sounds like it took a while, but justice may have been served.
Maybe, yes.
So some additional tales of rough justice, or if you prefer, creative alternate dispute resolution from the early territorial days. Justice Brown heard a case in which the same tract of land in Pig's Eye, east of St. Paul, was claimed by Pierre Perrant and Michael Leclerc. Brown may have doubted his authority to decide questions of title to land, but he went ahead with the case anyway. He determined that neither party had staked out the claim properly, but he also decided that whoever got to the land first got it. Neither man had a horse, so a foot race ensued, 8 miles one way. Leclerc won and was able to place his landmarks upon the property in the presence of witnesses, and he got the land. Another story tells the story of a blissfully unnamed justice of the peace who, before reaching a decision, would also adjourn court for a short time and take a walk through the neighboring cornfield. One day, an observer, curious about this particular practice, left before the adjournment and hid himself in the cornfield. He reported the judge came out, took a chip from his pocket, spit on one side, said, "Wet for the plaintiff, dry for the defendant." Wet, plaintiff wins. Marches back in and announces the decision.
So a story of the elements interfering with doing justice. We already heard about the problems with getting jury witnesses down to Prairie du Chien. A land dispute case was being tried and it was submitted to the jury. But there was little room inside the makeshift courthouse. As we'll talk about it a few times, a court was often held in businesses or bars or hotels because there weren't courthouses. And there wasn't room for the jury. So the jury was forced to deliberate outdoors. It was midwinter and here I'm quoting, "There was not much comfort in discussing the evidence with the mercury pretty near zero and the wind coming down from the north at the rate of about 40 knots, which almost congealed the breath as each of the members of the jury endeavored to explain to the others the way in which he understood the evidence. One juror held out for a verdict contrary to the others." That's my 12 Angry reference. "After some efforts to reach agreement, he declared he had been out in the cold long enough and that he would not be frozen into a verdict contrary to his belief. He walked off across the prairie." 12 angry or cold jurors. Isaac Atwater, attorney for the plaintiff and later Justice of the Supreme Court, demanded that the offending juror be held in contempt of court, but the judge refused and simply recorded the disagreement of the jury. The plaintiff was disillusioned and didn't seek a new trial. It was reported, however, that he, again, I'm quoting, "obtained a slight satisfaction in an encounter with the defendant in a snowdrift on the disputed claim not long after the farce of the trial." I'll mention one other case of a juror disappearing. There's a story about a case that was being tried and had gone on for several days in testimony, and then the jury started to deliberate and was arguing for several days. And at that point, one of the jurors jumped out of the second floor window and disappeared completely, never found. And they just, the case was dismissed because they didn't have a jury to decide at that point.
So Charles Flandreau, and we'll learn a bit more about him shortly because he was also on the Territorial Supreme Court and also became a member of the First State Supreme Court, was known for the stories he told about early days in Minnesota legal history. One story from the early 1850s was about Thomas Cohen, who later became the first attorney to enroll as a member of the bar after statehood, one of those first 20 that the chief spoke about. Cohen moved to Traverse des Sioux and decided to study law. He proposed to study with Judge Flandreau, and after about 6 weeks of diligently reading, principally devoted to the statutes, Flandreau admitted him to the bar. Although a successful attorney, a fine speaker, often making an excellent argument, Flandreau reported that Cohen was never quite certain about the law of his cases. This deficiency, however, was made up by dash and brilliancy, and he got along swimmingly. One day, Flandreau recounts, Cohen came into my office and said, "Judgey, I'm going to have a big trial down in Le Sueur tomorrow. It involves $2,500. It's the biggest case we've ever had in the Valley. And I think it ought to have some Latin in it. And I want you to furnish me with that ingredient." Flandreau says, "Tom, what's it all about? I must know what kind of a suit it is before I can supply the Latin appropriately, especially as I'm not so sharp on Latin myself." He said the suit was an insurance policy. He was defending on the ground of misrepresentation made by the insured in the making of the policy. And he must have some Latin to illustrate and strengthen his point. I mulled over the proposition, looked up some books and maxims, and finally gave him this: non haec infidere vini. which I translated to mean, I did not enter into this contract. He was delighted and said, there ought to be no doubt of success with the aid of this formidable weapon. And he made me promise to ride down with him to hear him get it off. So the next day we started off, and in crossing the Le Sueur Prairie, Cohen was hailed by a man who said he was under arrest for having kicked a man out of his house for insulting his family, and he wanted Tom to defend him. The Justice Court was about a mile from the road in a carpenter shop, the proprietor of which was the Justice of the Peace. Tom told the man to demand a jury, and he would stop on his way back and try to help him out. When we arrived at Le Sueur, we found that the insurance case could not be heard that day. And starting homeward, about 4 o'clock in the afternoon, we reached the carpenter shop. There we found the jury waiting. We hitched up the team, and I spread myself comfortably on the pile of shavings to witness the legal encounter. The complaining witness proved his case. Cohen put on his client on the witness stand and showed provocation. Then he addressed the jury. His defense was want of criminal intent. He dwelt eloquently on the point that the gist of the offense was the intent with which the act was committed. And when it appeared that the act was justified, there could be no crime. Then, casting a quizzical glance at me and striking a tragic attitude, he thundered, "Gentlemen of the jury, it is indelibly recorded in all the works of Roman jurisprudence, non haec infidere veni, which means there can be no crime without criminal intent." The effect was electrical. The jury acquitted the prisoner, and we drove home fully convinced that the law was not an exact science. Where are we at now?
So I'll just do this last little.
Okay. Oh, right here.
Yes,
This
yes.
part. Okay.
Uh,
That's still mine? Yeah, I think so.
yes.
So trying to put a wrap now on the pre-territorial period. Legally, Minnesota's pre-territorial days were marked with only the barest outlines of a legal system where judicial power was exercised by men. Yes, men. And credit for that line goes right here. Who typically had other full-time occupations. Nonetheless, as Chief Justice Sharon wrote in that Mitchell Law Review article that the chief mentioned about those early days of Minnesota legal history, and I quote now, "Out of this milieu, with Sibley and Brown at the helm, the legal system in pre-territorial Minnesota marked itself as fair and commonsensical, reluctant to intervene or act except when matters of substance were presented, yet not at all unable or unwilling to assert itself authoritatively when the cause of justice required." All in all, it was an auspicious beginning.
So one last little bit of information before we move into the territorial period. Remember, this has all been pre-territorial. About buildings. I've already mentioned the fact that there weren't courthouses in most places, and court was held in other locations. The first courthouse in geographical Minnesota was built, or at least begun, in Stillwater in the pre-territorial period. After the 1847 term of court, a group of citizens from Stillwater pledged $1,200 if the county would contribute the remainder. And John McCusick, whose store was being used to hold court hearings and therefore probably had a reason for wishing there to be a courthouse, deeded a plot of land for it. Work was begun in 1848, and the building, only partially constructed, was accepted by the commissioners of the newly created Washington County of Minnesota Territory on August 1st, 1849. It continued to be used for about 15 years. Of that building, Charles Flandreau, already then a justice, later a justice of the Territorial Court, said the courthouse was perched upon the top of one of the high points in that town, and many are the citizens who have been winded and made to blaspheme in ascending to its lofty pinnacle. The picture you see, and it does indicate that on the slide, it's not that courthouse. There are no pictures. I looked for pictures of that courthouse and I couldn't find a picture of that courthouse. But this is the oldest standing courthouse in geographical Minnesota, and it was built to replace the one that I just talked about. So it's at least a vision of some of that early time, although it came a little bit later than this first courthouse built in 1847, 1848, 1849.
I don't know, Carol, looks like a hike to me. So now we're working our way toward the creation of Minnesota Territory. And as the historian Baland noted, and I quote, "The creation of Minnesota Territory was marked by ambition, hope, anomalies, and audacity. And the story of how Minnesota Territory came to be established both confirms and perhaps illustrates Baland's observation. When Wisconsin was admitted to the Union in 1848, its western boundary, as we mentioned earlier, was fixed as it presently exists along the Mississippi and St. Croix rivers. Since Iowa had been admitted 2 years earlier, the creation of the state of Wisconsin meant that all of the territory west of the St. Croix and the Mississippi, as well as north of the Iowa line, became a kind of political no man's land without organization or government of any kind. This situation quickly led to demands that a new territory be organized. And on August 4, 1848, a call for a convention to be held at Stillwater was issued. The so-called Stillwater Convention met on August 26, 1848. The 62 participants unanimously selected Sibley as the disenfranchised territory's delegate to Washington, where he was charged with the task of presenting the convention's memorial to President Polk. The memorial asked the president to call the attention of Congress to their situation and to recommend the early organization of the territory of Minnesota. So that's what's going on in the Stillwater area, the Stillwater Convention. However, a few weeks after the Stillwater Convention, a somewhat different idea as the basis for a petition to Congress for a territorial status began to gain currency. This happened among the residents of St. Paul and Mendota. This idea, which was first espoused by James Catlin, the last secretary of the Wisconsin Territory, held that the territorial organization and government of Wisconsin was still effective in the remnant part of St. Croix County, even after Wisconsin's admission into statehood. In Catlin's view, he had become the acting governor of the remnant. Since the last delegate to Congress from Wisconsin Territory was about to resign, Catlin concluded the best procedure to follow would be to hold a special election to name a bona fide delegate to Congress who could then work with that body to secure approval for the territory. The special election was held October 30, 1848. Sibley emerged as the clear winner, and he left for Washington almost immediately. By January 15, 1849, he had persuaded a somewhat doubtful House Committee on Elections to seat him as a delegate to Congress. Less than 3 months later, Minnesota was a territory. The Organic Act, passed March 3, 1849, established the territory of Minnesota. The Organic Act provided for a Supreme Court consisting of a Chief Justice and 2 Associate Justices, and 3 district courts and courts for probate and justice of the peace. One of the first acts of the newly appointed governor, Alexander Ramsey, was to divide the state into 3 judicial districts and to assign a justice to each. The first district was seated in Stillwater, the second in the Falls of St. Anthony, and the third in Mendota. The division is at least roughly demonstrated on the slide on the screen, but not long after that initial allocation, the territorial legislature altered things, and each of the members of the Supreme Court wound up responsible for a slightly different district. The justices under that Organic Act were provided an annual salary of $1,800 each. In addition, and as the chief mentioned, $5,000 was granted for the purchase of a library for the use of the governor, judges of the Supreme Court, legislators, and attorneys. President Zachary Taylor appointed Aaron Goodrich of Tennessee as Chief Justice, David Cooper of Pennsylvania, and Bradley Meeker of Kentucky as Associate Justices. Aaron Goodrich, who was born in Cayuga County, New York in 1807, first served in the Tennessee State Legislature and then became friends with Zachary Taylor. When Taylor became president, he appointed Goodrich as the first Chief Justice of the Minnesota Territorial Supreme Court. This happened June 1, 1849. Goodrich presided over the first district term of district court and convened the first session of the Territorial Supreme Court in St. Paul, January 14, 1850. Goodrich came under attack from early in his term. Initial complaints against him failed, but then 18 members of the bar sent a petition to President Fillmore alleging various improprieties by Goodrich, including undignified deportment on the bench, holding court in the bar room of a public house in which he had a pecuniary interest, and adultery. Goodrich responded to each of the charges and claimed there was a conspiracy against him by Henry Rice and his political supporters, motivated by Goodrich's support for Rice's rival, Henry Sibley. With the letter, Goodrich also was able to submit affirmations of good character from many members of the territorial legislature and Governor Ramsey and the editor James Goodhue of the Minnesota Pioneer. Fillmore was at first not inclined to remove any of President Taylor's appointees, but the pressure on Goodrich was quite strong, and Fillmore finally removed him November 13, 1851. Goodrich was an avid book collector, and at his death, his collection was valued at about $50,000, roughly 1.6 million in today's dollars. Goodrich Avenue in St. Paul is named after him.
So before we move to the next justice, I'm going to tell two other little stories about Goodrich. You already heard there were some allegations of impropriety of different kinds. One story told of him holding court, as you've heard, in the bar area of the St. Paul Hotel. I think it's been variously, I saw it as the American House Hotel, the American Hotel in St. Paul, where he lived. Englishman Edward Sullivan described it this way: the judge was sitting with his feet on the stove, with a chew as big as an orange in his mouth and a glass of some liquor by his side. The jury were in nearly the same elegant position. The prisoner was sitting drinking and smoking with his back to the judge and looking the most respectable and least concerned of the party. Although it struck me that there might be a good deal of justice, there was very little dignity in the application of the law in Minnesota. And then the last tidbit about Justice Goodrich. You heard he was removed. He challenged that removal. There were several justices of the Territorial Supreme Court over the few years who were removed and challenged and said the president did not have the authority to remove them. It was often because of a change in administration, but there were questions about the president's authority. And there are actually some cases today raising issues of presidential authority over removals of executive officials, so there may be some relevance. But Justice Goodrich took it one step further, and he sued for a writ of mandamus to the U.S. Supreme Court to get paid. He said he wanted to get paid for the entire rest of his 4-year term, even though he had been removed and was no longer serving. At the Supreme Court, it's a decision in 1854, the court majority ruled that they had no power to order payment of money from the Treasury. The writ mandamus could not be used for that purpose. But the majority opinion only reached the procedural aspect. In dissent, Justice McLean said that the president had no authority to remove the Chief Justice and mandamus should issue. So he took his claim up, and lost, as others did when they were objected to being removed.
Yeah. And if I've got it straight, Carol, you dug that out of some of your notes that you'd compiled years ago.
Years ago.
Yeah, right. Cooper, one of the first named associate justices, was born July 22nd, 1821 in Maryland. He attended Pennsylvania College and was admitted to practice in 1845. He involved himself in Whig Party politics and came to the attention of President Zachary Taylor, who nominated him at age 28 for a position as Associate Justice on the Territorial Supreme Court. This happened March 15, 1849. Cooper moved to Minnesota and settled in Stillwater, and he presided over the 3rd Judicial District. Cooper also came under fire. Unlike Goodrich, Cooper was not attacked for lack of legal ability. Rather, he was so certain and set in his views that he became irate with anyone who dared to disagree with him, including other judges. He was attacked for absenteeism, for being a drunkard, and for owing money to local merchants and other service providers. In 1851, James Goodhue, the editor of the Minnesota Pioneer, criticized Cooper in his newspaper. Cooper was out of town the day the article appeared, but his brother Joseph confronted Goodhue on the street. Joseph was stabbed, Cooper got shot, Joseph died of his wounds, and Cooper was seriously injured. He served until April 7, 1853. And if we ask Carol for a footnote on that, I think the story was he died as a drunkard somewhere in Nevada. Bradley Meeker, born in Fairfield, Connecticut, March 13, 1813. He attended Yale College, moved to Kentucky, supported himself as a teacher while he studied law. He was admitted to practice 1838, made a name for himself in law and politics, and was appointed to the Territorial Supreme Court by President Taylor, June 1, 1849. Meeker has the distinction of being the least controversial of the first 3 justices of the Territorial Supreme Court. He remained in Minnesota after leaving the court, serving on the Territorial Legislature and as a member of the Minnesota Constitutional Convention. He was one of the first regents of the University of Minnesota and a charter member of the Minnesota Historical Society. And as the chief mentioned, Meeker County is named after him. As noted, each of the justices presided over trials and motions in the district court to which they were assigned, and then they reassembled en banc to sit as a Supreme Court. So the justices ended up reviewing their own decisions. In all, 10 justices served on the Territorial Supreme Court from 1849 to 1858. Let's learn a bit about the other 7 who came after Goodrich, Cooper, and Meeker. Jerome Fuller, and I'll for a moment include Henry Z. Hayner. They're the only 2 for whom the library, Carol, and everybody else that tried could not find a photograph. And so the best we could do was to put up on the screen a word or 2 about each of them, as well as their signatures. Fuller was appointed by President Maynard Fillmore November 13, 1851, to fill the vacancy created by the removal of Goodrich. He traveled to Minnesota in time for the spring 1852 term of district court and heard cases during the July term of the Supreme Court. Newspaper accounts suggest that he conducted court in an exemplary manner, but opposition from the senator in New York blocked his confirmation. Nobody realized that here until months later when the word finally reached St. Paul that he never got confirmed. When word did reach St. Paul that Fuller's nomination had been rejected, he thought about fighting it, but relinquished his position and returned to his former home in Brockport, New York. His term of service ended December 16, 1852. Hayner was born in Brunswick, New York, 1802. He attended Yale College, was a New York State legislator, ran for the Senate, and then was nominated by President Fillmore to replace Jerome Fuller in August 1852. He arrived too late for the fall term of court and served until 1853 when he and other members of the court were replaced by appointees named by President Franklin Pierce. Hayner thus never actually presided over a term of court. His duties were limited to matters considered in chambers and decisions as a district court judge. In that role, however, it is believed that he imposed the first death sentence in the state, and he also declared a law banning liquor unconstitutional.
I wonder if we should just recognize all the justices and then go on, because we may run out of time if we go through all the biographies.
Sure.
So we've got, you can, so it's Andrew Chatfield, and you can see the dates here, and we had the chart that put them together as well. We can come back if there's time afterwards to go back to some of the details. Do you want to give any small details? Andrew Chatfield, Moses Sherburne mentioned before, a source of a county name.
City of Chatfield in southeast Minnesota is named after Justice Chatfield. Then William Welch, excuse me. And the notes I had indicated that he was either the only one that actually lived in Minnesota when appointed, or if not, if there were three, as the chief suggested, then he was the first one that was kind of homegrown at the time of his appointment. The last two were Rensselaer Nelson and Charles Flandreau. Nelson's father later became a justice on the U.S. Supreme Court, and Nelson moved to Minnesota in 1850. Excuse me. Just one tidbit about him. A colleague, learning that Nelson planned to practice law in St. Paul, wrote, "My dear young friend, we have a population of 650 of them are lawyers, most of them starving. I advise you to take the next boat east because you have no chance here. We have too much trouble with the lawyers we have already." And then Charles Flandreau, about whom we've heard a bit in terms of some of his stories and anecdotes. One of the historians writing about him said that Flandreau helped hew out the groundwork upon which rests most of the jurisprudence of the state.
So this is back to a picture of the first three justices, because I want to talk a little bit about you know, they served as Supreme Court justices, but also as district court judges for second and third district, and a little bit about the beginnings of those terms, first district, second district, third district. They all began their work in August 1849, about 5 months after the territory was created. The first term of the first district, so that would be Aaron Goodrich, was convened in Stillwater on August 13th, 1849. Although only one justice, that is Goodrich, would preside over the district, both Goodrich and Cooper were present because it was the ceremonial beginning of the court. Meeker was not there because he hadn't yet arrived in the territory. An unexpectedly large number of cases were already on the docket, apparently, either 35 or 60, depending upon which version of the story you see. There were also an unexpectedly large number of attorneys present because they needed to be sworn in to appear before the court. By one description, they were 20 attorneys of the lankest and hungriest description. At the beginning of the term, there was apparently some chaos, or at least confusion, because all the lawyers came from different jurisdictions and they all operated under different procedural codes, and they all wanted their own procedural codes, and they didn't believe that any of the other procedures would do. And so there was a lot of confusion to try to figure out how to run court. The Chronicle and Register newspaper reported, however, that by the urbanity, conciliatory firmness, and harmonious course taken by the court, matters were in a great measure systematized, although there are some stories later that suggest not so much. There were 10 indictments returned by the grand jury and panel for this first term of court. Only one was tried that term. The accused was William Phillips, first district attorney of Ramsey County, who was charged with assault with intent to maim because he had allegedly drawn a loaded pistol during an argument. Apparently, the law did not permit Phillips to testify in his own defense, and he was convicted and fined $25. But he told his story, not in the courtroom, but outside the courtroom. And his story was that he'd been electioneering for Henry Rice, and because of the unsettled state of the country, he found it difficult to get his meals regularly. To solve this, he got into the habit of putting cheese and crackers in his pocket along with his pistol. And when he pulled out, it had gotten crunched up and the pistol was filled with crackers when it came out of his pocket. But the complaining witness thought it was ammunition, presumably some sort of buckshot. You know, whether he would have been believed if he told that story in court, we don't know, but he was convicted for the loaded pistol.
Good try.
The first term of the second district was convened in St. Anthony Falls on August 25th, so just a few days later, about a week and a half later, I think. Justice Meeker presiding, he'd apparently made it into the territory. There was no courthouse. We've already mentioned that before. There hardly ever was a courthouse. So the court met at the house of Reuben Bean, the government miller. A grand jury was convened, but there were no cases. So the justice dismissed the jury with a very few handsome remarks, and the jurors, the justice, the U.S. Marshal, and a few attorneys from St. Paul adjourned to an excellent dinner provided by Mr. Bean. The first term of the 3rd District was held in Mendota on August 27th, 1849, just 2 days after the 2nd District met. Justice Cooper presided in a spacious warehouse fitted up for the occasion. Again, no courthouse. A grand jury was impaneled with Henry Sibley as foreman. Justice Cooper made a very lengthy presentation to the grand jury, exhorting them to execute their important duties faithfully and fearlessly. He said they held, quote, a position midway, as it were, between the rights of the citizen and the liberty and the well-being of the country. The first consideration with which I hope fully to be able to impress your minds is that you are exercising a public trust of the greatest moment to your fellow citizens. For upon your determinations will frequently depend not only their fortunes, but their reputations, not only their reputations, but their personal liberties, not only their personal liberties, but even their lives, and not only the fortunes, the reputations, the personal liberties, and the lives of the citizen, but the peace and harmony of society and the dignity and well-being of government. A beautiful oration. It goes on, printed out. It was printed in the newspaper. Pages and pages and pages of very beautiful language. Became authoritative, was often referred to as Cooper's charge over the next years. The only problem was only 11 of the 16 jurors could understand English. The charge had to be translated into French for them, and it reportedly was, though I have to wonder if it really was, because it was pages and pages of oration. Cooper also spoke to the attorneys present to be sworn in that day, and that address was also published in the newspaper. Among the things he said, the judges may appreciate this oration. It will be my object to see that the rules of courtesy and gentlemanly bearing be esteemed and respected. And painful indeed would it be to me under the necessity of punishing their willful infractions. It shall likewise be my object never to be harsh, petulant, or oppressive, but to observe towards you a strict impartiality and courteous manner. This is due from the court as well as from the bar. He continued in a somewhat self-deprecating way. Coming to the bench, gentlemen, young as I am, he was 28. I shall necessarily need much indulgence at your hands. The statutory provisions of the Territorial of Wisconsin, until within a few weeks, I had never seen. He came from somewhere else, right? And such a mess of incongruous imperfections as they are, it cannot be expected that I am very familiar with them. The rules, likewise, of our courts here are entirely dissimilar to those which I have practiced, but I shall endeavor to adopt for our governance a system as nearly like those to which you have been accustomed as practicable. That I will frequently err, I doubt not. That is but human, and older, more experienced, and far more learned men than I am have often erred in the construction of laws. But whenever I do err, I shall not hesitate to retrace my steps if possible, or to give to those who feel themselves aggrieved every facility in my power to have a hearing before a higher tribunal. After that full oration, there was no business to conduct, and court dismissed. Maybe we just talk a little, just briefly, the jail. I didn't know what you're going to say, but there were a few structures, right? The old jail, and that is, I don't know which old courthouse this is. Do you remember? Second courthouse.
Second courthouse, yeah.
Okay. So a few stories of the cases heard by the Territorial Supreme Court. This was the first case argued, Gervais versus Powers. It involved a claim that the defendants had trespassed on the plaintiff's land to take back their cow, which the plaintiff had been keeping because it was a stray that had wandered onto his land. The defendants didn't show up at the hearing, and the justice of the peace ordered the defendants to pay the plaintiff for keeping and feeding the cow. The Supreme Court actually didn't decide the merits of the case, but reversed the verdict on an important procedural ground. The theory on which the justice of the peace had ruled for the plaintiff was different than the theory raised in the summons sent to the defendant. So when the summons came out, they were told what the case would be tried on, And the court said they might have decided not to show up because they thought, well, that argument is so absurd, it will never win. And so we might not show up. But since they changed the theory in the decision, it was overturned. I'm going to skip this, and I can, if there are questions, if there's time afterwards, there's lots of interesting stories, but we don't want to keep you too long. So I'll move on to the next case is the Fort Snelling case. That one we should tell you about.
Just be sure I've got one early case from 1851 is called Ex parte Lee. Certain soldiers at Fort Snelling came to desire a release from their service prior to the expiration of their period of enlistment. They hit upon the idea of applying for writs of habeas corpus, granting their discharge. The Ramsey County probate judge, Henry Lambert, granted the first few requests. The idea soon became the most popular one at the fort. Colonel Francis Lee, commander of the fort, speedily petitioned the Supreme Court for a writ of prohibition, restraining Judge Lambert from granting such relief. The petition was granted, and life at the fort returned to its usual routine. I don't know if we have time for Smith, but I'd like to tell the lightning story in penmanship.
Yes.
Is that okay?
Yes.
There's an interesting story about, we've got to at least tell an abbreviated version. So this is the secretary of the Territorial Legislature, if I remember right.
Yes.
And he was sued for failure to pay a debt, and the plaintiff sought to have him arrested on the theory that he was about to abscond. The Supreme Court affirmed the district court's denial of the writ of attachment on the grounds that there wasn't enough evidence to infer that Smith would abscond. But abscond he did. And one of the government debts left unpaid was the cost of printing the opinions of the Supreme Court. The editor of the local paper, who had the contract for printing the opinions, castigated Smith in the Minnesota Pioneer. He stole into the territory. He stole in the territory. And he stole out of the territory.
Just briefly mention a few additional cases from the Territorial Supreme Court. Cooper versus Brewster. This involved the brother of Justice Cooper, the one who was out fighting on the street and was injured and caused the injury. He defended the justice's honor. In the 1850 election for Minnesota Territorial Representative, it was Henry Sibley against Henry Rice's handpicked candidate, Alexander Mitchell. Cooper gave a man named Buford a promissory note for $100 to be paid when Henry Sibley is elected representative. Sibley won. Brewster, who had come into the possession of the promissory note, now wanted payment. It went to the Territorial Supreme Court. Justice Cooper wisely recused himself from the decision, but they concluded that the promissory note was in effect a wager upon an election. It was buying a vote, and it could not be, therefore, allowed. It was gambling on the election. It's a sacred trust, the voting confided to him by his country, which he is bound to exercise in such a way only as in his judgment will contribute most to his country's welfare. And they would not pay the promissory note. This case I'm going to skip. Again, you want to ask me about it afterwards. I'm a legislation and regulation teacher. It's an early statutory interpretation case applying a justum generis, if you're familiar with that doctrine, but not important enough really to tell the story. But I do want to say something about these railroad cases. It's the last case that we wanted to talk about. There were a series, there are 5 cases here. 3 of them at the US Supreme Court and 2 of them the Minnesota Territorial Court. The Minnesota Territorial Legislature was hoping to encourage agricultural development and settlement, and they thought development of the railroad was important. They passed a statute incorporating the Minnesota Northwestern Railroad Company, purporting to vest title in the railroad of land that Minnesota did not yet have, but thought perhaps would be deeded to Minnesota from the US. Shortly afterwards, the US Congress did grant land to Minnesota for that purpose, about 1 million acres. Being alert to what was happening with this land acquisition, the bill was originally drafted to avoid a land grab, saying only subsequent legislatures could allocate the land. In a last-minute language change, the text was amended in a way that could allow or be interpreted to allow the railroad to take the land. The finesse was noted, however. Congress investigated, and the land grant bill was repealed. But the railroad pressed the issue, and there were a series of trespass cases with someone. You see Rice's name here. Rice, and he may have been a director of the railroad, but they would go and cut timber in order to have a trespass claim to figure out who owned the land. The first first case was brought to the Territorial Supreme Court, ruled in 1854 that the first land grant bill vested lands in the railroad immediately and could not be taken back. That was appealed to the US Supreme Court. The US Attorney General thought the record was incomplete and that more had to be developed below, so the Supreme Court dismissed the appeal. So that first US citation is just basically a dismissal for that reason. It went back to the Territorial Supreme Court, which in 1857 ruled for the railroad, but it neglected to enter a final judgment. So the US Supreme Court appeal was once again dismissed. At that point, the state of Minnesota was created, and the new federal district court in the state of Minnesota entered judgment for the railroad based on the earlier Territorial Supreme Court opinion. But when that decision went up to the US Supreme Court, the court concluded that the repeal of the original land grant was valid and the railroad had no claim to the land. A very long path to an answer of great consequence to the state, to the territory, to the state, and of course, to the railroad. And just in summary, Justice Hudson already mentioned this Territorial Supreme Court considered 161 filed matters, of which 119 were decided by opinion, 58 of them written. We've shared just a few of them with you.
Can we put the slide of the second courthouse back up?
This has gone blank, so I can't.
Well, anyway, you remember the slide of the courthouse.
This went blank.
Just one story, and then Carol will do a wrap, and we'll try to answer any questions you might have. So
Courthouse.
yeah. There we go. Paper to the rescue. Construction for the new courthouse was estimated at $5,000, and this money was raised by issuing bonds. However, two of the county commissioners could not write their names, and the bonds which had been sent to New York for negotiation with X marks were rejected as improperly signed. One William Pitt Murray undertook to teach the commissioners how to sign their names, and the next day properly executed bonds were again on their way to New York. The handwriting on the two newly obtained signatures was said to so strongly resemble that of Mr. Murray's that his reputation as a lightning instructor in penmanship was never again questioned.
So I think we just have a few words to sort of summarize kind of the period. In assessing the work of the Territorial Supreme Court, it's important to remember what those early justices were up against. They had no law library. They had no accumulation of their own precedent to rely on. They relied on New York a lot because a lot of the lawyers came from New York, and so they cited those cases, as well as Wisconsin, where they were borrowing the law. They had attorneys appearing before them and the other courts who came from many other jurisdictions of the country. Many of the cases presented matters of first impression, of course. Because of the lack of precedent, decisions often rested more on principle rather than authority, although as noted, sometimes New York authority. Despite these challenges, there were cases decided on practice and procedure, partnerships, contracts, property, liens, negotiable instruments, and promissory notes, slander, and criminal law. There were a lot of, almost every case that went up to the US Supreme Court from Minnesota were land cases. There was a lot about trying to take land or who had bought it or who had paid or hadn't paid for a claim. There was some rough justice. We've already had shared some stories. There are others we could share as well. But despite that, the various reflections on what happened. Isaac Atwater, who was later an Associate Justice of the State Supreme Court, observed that the different courts of the territory, according to my own experience and observation and supplemented by that of others, were of greater average ability than those of most Western states in their territorial days. Charles Eliot, Associate Justice of the State Supreme Court in 1905 to 1909, said that despite the difficulty of operating in a newly organized territory, the record made by the Territorial Supreme Court is eminently respectable, and very few, if any, decisions were overturned. So I don't know if that's quite the measure, but
Just like now.
just like now. So a record eminently respectable, and we hope interesting for you to hear about.
Thanks a million.